Okay, as informed earlier, that this part is the part number 2, which is in the continuation of the part number 1 and which have been already uploaded. So those of you have not watched, better go for the session number 1, then come back to the session number 2, and those who have watched, try to answer all those questions which have been asked in that particular session. And then if possible, do ask some of the questions for for the today's session as well. All right, now you can continue, please.
Okay, thank you, ma'am. Hello, everyone. First of all, apologies due to the mic issue. And second of all, welcome to the session of POLITY 365. Today, we are going to continue from yesterday. And the topic that we are going to approach first is abrogation of Article 370. Why it was in news is probably everyone has an idea, right? Supreme Court just said that the constitutionality of the actions taken by the Union related to Article 370 is okay, it's acceptable. From prelims point of view, we need to remember what are the major points in this particular judgment that would be aiding us knowledge wise. So if you can see here, it says it says repeal the special status of Jammu and Kashmir under Article 370. Here we have three key terms: repeal, special status, and Article 370. We need to remember what every term means in order to solve questions of PYQ as well as the upcoming prelims, right? So repeal is simply you could say that government has said this particular thing is discontinued. So whenever parliament orders or parliament decides to discontinue a particular mode of action, it is repealment. What it repealed was the special status of Jammu and Kashmir, which was under Article 370. First of all, Article 370. So it was a temporary transitional provision which was introduced after the then king of Jammu and Kashmir decided to accede his state in the dominion of India. Okay, this particular provision was contested whether it was temporary or transitional, and finally Supreme Court held that Article 370 is indeed a temporary and transitional provision. Second, Jammu and Kashmir whether retained any element of sovereignty or not. Now the actions of government in order to remove this particular act did not sit good with some minds in the country, so they challenged it and they uphold it that there was a sovereignty with the Jammu and Kashmir Legislative Assembly, which was a representation of the power of Jammu and Kashmir hierarchy of kings, right? Supreme Court held up that there was no element of sovereignty of Jammu and Kashmir, because as soon as Jammu and Kashmir agreed it to accede itself in the state, it became what we generally say a state, and this state is the state which is mentioned in Article 1. Article 1 says that India is a union of states. India is an indestructible union of destructible states. So Jammu and Kashmir, when it acceded to India in 1947, became a destructible state of the Union of India. Moving on, we also saw that there was this whole repealment. Which body did it? It was Parliament. Parliament was previously handed over the power to amend the Article 3. Here we need to remember that when Parliament is creating a new state or is merging two state, right? Such actions done by parliament are done through simple majority. There is no special majority required. Okay. So parliament by law can form a new state by separation of territory from any state or by uniting two or more states or parts of state, right? And under Article 3, there is a particular clause which basically says that this particular action for simple majority is not bounded. It is not bounded for states by definition. It also includes union territory. Moving on, we have here a historical context of Article 370, which I would prefer to be read while you are giving mains. From prelims point of view, it has little significance, right? The next subcomponent is Article 3, which provides that Parliament by law can form new states and alter areas, boundaries, or names of existing state through simple majority. Here, this particular action, whenever Parliament has to do, it has to present a bill, and this bill can only be introduced on the recommendation of President. So here is your one pointer that you need to remember regarding Article 3 from point of prelims. What? That there is a must condition that President must recommend introduction of any bill that is going to form or alter existing states or form new states, right? And this can be done in either house of parliament. So it's not like money bill where the money bill has to be introduced in Lok Sabha. No, this particular bill can be introduced in either house of parliament. Moving on, the bill can affect certain characteristics which have been mentioned with respect to Article 3 in SR Bomai case, right? So this was Article 370 and its abrogation. Next article is National Capital Territory of Delhi Amendment Act 2023, right? Government recently introduced this particular act and the act received the assent of the president. Okay. What the act consisted of was can be summarized in 3 points. First, it established an authority which is called National Capital Civil Services Authority. It expanded and curtailed certain powers of LG and gave a proper definition of what LG can do or do not. And other than that, it re-signified what central legislative assembly, that is your parliament, or central executives can do when it comes to the matter of Union Territory of Delhi. There are some key highlights. Again, it is more important related to mains, but in the past we have seen that UPSC has been asking certain questions which were meant to be asked in mains but came in prelims, while certain prelims question have been asked in mains, right? So let's try to skim through this article, remembering as little as information, but at least a percentage of it. See, what the amendment brought first, it was a National Capital Civil Services Authority. You could compare this to a finance commission in its structure or in its functions. How? See, what they did was that this particular authority is a statutory authority, and it would be recommending to LG about every civil services matter, which are transfer posting or there is some particular issue. Acha, okay. So I'll be zooming on the particular page as some guys are not able to view it properly. If you are able to view it properly now, kindly write in the group that it's now properly visible. Cool. Okay. So Coming back, it is going to recommend to LG related to every administrative or civil administrative matters. The composition here is that there would be CM of Delhi, who would be chairperson. The principal Home Secretary of Delhi government would be the member secretary, and then the Chief Secretary of the Delhi government would be the member, right? Now, in this particular committee, central government appoints these two particular people, that is Principal Home Secretary as well as your Chief Secretary, while your Chief Minister of Delhi is an elected official, elected political official. So here is some contentious that it sort of violates the democratic principle. Again, it is from the perspective of mains. Here we only have to remember the composition. Good or bad would be discussed further on. Then what are the powers of LG? So LG can act solely on his discretion. That is, there is no recommendation required of any minister or of council of ministers or even chief minister, right? What are those matters? First, there are particular matters outside the legislative competence of Delhi Legislative Assembly which have been delegated to LG. Remember, there are two types of delegation when it comes to certain matters which are outside of the legislative functions or legislative scope. We must have read about residuary powers, which are sort of similar to your Canadian structure, right? And then there is second set of matters which are generally classified under extrajudicial. See, the difference between extrajudicial and residuary is residuary basically means everything which is not mentioned under the list or under the scope of legislation. It is residuary. But if there is particular matter which was outside the competence here, outside the scope of legislature, if it is targeted under any act or statutorily, it has been clarified that this particular legislation is going to take care of this matter, right? Which was not initially mentioned in your union list or state list, right? Then it is called extrajudicial matters. So LG is free to act on his discretion on the matters which have been extrajudicially conferred upon him, and they have to be outside of the legislative competence of your Delhi Assembly. Second, again, they have written the straightforward fact that any judicial or quasi-judicial functions, again, which have been imparted or been decentralized to LG via any act. Then comes primacy to LG. So here is another contention that is in this particular act. What? That if LG find that particular action needs to be taken, which is contrary to the recommendation of NCCSA, then LG decision would be final. It is sort of a veto power. But in this particular arena, we have only two participants. One is LG and the other is the authority. So if authority is making any recommendation and LG finds it incompatible to the circumstances, he may give or he may take an action which is completely contradictory to the NCCSA, right? Then it also provided a particular hierarchy that there have to be certain matters which needs to be submitted to LG by the ministers via through the head, who is chief minister, or the administrative ally chief secretary. What are these matters? So if you remember your article 51, right, it is about keeping peace and order with friendly powers. Similarly, anything which is about peace of Delhi or relation between other parties and Delhi government, such actions need to be submitted to LG. And finally, where there is a sole discretion of LG, but a minister has to take some sort of action or some sort of uh, route of or series of steps, it has to be submitted to LG. A minister cannot go on his own, right? There is a governance model of Delhi NCT which has a very long history. It started from 1951. Currently, the structure is defined under Act of 1991, which was passed after 69 Constitutional Amendment Act was introduced. It made Delhi the capital of India, as well as it provided for an act where we have your function and functionaries for Delhi Legislative Assembly, and the particular act is called, I think it is mentioned in brief, the Government of National Capital Territory of Delhi Act 1991. Okay. Again, you have certain articles which relate to Delhi, such as Article 239, which basically is about union territories, and there is an Article 239 AA, which makes Delhi a union territory with a legislature, right? And all these actions have been primarily done on the basis of recommendations of S. Balakrishna Committee. This is again something that needs to be remembered for your prelims questions. Okay. Also, there is some confusion generally, especially who are giving their prelims first or second time. So here to re-clarify, Parliament, since Delhi is a union territory, so Parliament has powers to legislate on all matters related to Delhi, whether the subject lies in state or concurrent list, right? Delhi is not a state, it is a union territory. And in perspective of union territory, Parliament has powers to legislate on all matters. On all matters. Okay? Okay. So this was about your Delhi. Delhi ka recent amendment of 2023. Next, we have preventive detention. Article 21 is something which everyone remembers very fondly. However, there are two articles which are similarly not probably recalled by everyone, which are your Article 20 and Article 22. While Article 20 is in perspective of commencement of crimes, Article 22 is about preventive detention, right? So whenever a person has been put up under some protection, Achha. Huh. So there is a particular person who is probably going to create a chaos in the state, and the state feels that if this person is left alone, may lead to create instability or chaos in the state. So what does it do? It simply puts that particular person under preventive detention. This is a very simple definition or perspective of preventive detention. However, if you actually want to indulge what is preventive detention, who can do it, there are number of acts, and the more clarity is coming to the public's knowledge with each case that is being filed in judiciary, right? Here we are going to simply take a simple look on preventive detention, because recently when Supreme Court was hearing a particular case or a PIL related to preventive detention, it made an observation that these laws are colonial legacy and they need to be made or they need to be used only in the rarest of rare cases. See, Parliament has exclusive authority to make a law on preventive detention. कहाँ से आया? So we know Article 51, peace and order with our friendly neighbors. Then, if you recall, in Article 51A, which are your fundamental duties, in those particular provisions, we have certain duties which bind us to be a good citizen for our nation. Furthermore, we have article on emergencies such as 352, 356, 360. And most importantly, we have Article 14, which is your right to equality. After putting all these things in a mixer and making a juice out of it, there are certain provisions that Parliament felt had to be made in order to have a peaceful running in the a peace and order in this particular nation. So Parliament has been given this particular responsibility to make laws on preventive detention. One of its most common uses, does anyone know? You must have heard about this particular provision again and again by Home Ministry. You can type in the group so that I am also able to view if anyone can recall. Correct. UAPA. Right? So under UAPA, we have cases where people have been put in preventive detention because they were a threat to security of India. Right? In preventive detention cases, we have certain cases which have been able to basically put up what preventive detention is. However, I don't think you need to focus much on it except for the Article 2022, which is simple that if you remember, Article 2022 basically makes in proviso first that a person has to be informed within 48 hours on why he was arrested, what is the crime that he has committed, and then he may skip, he may basically challenge and to the court that these are particular provisions under which I was captured, but I have not done the same, right? So Article 3, Article 22 makes certain provisions which basically provides citizen to have a certain right when they are captured or when they are caught by our enforcement agencies. Some of them are, first, he has to be informed or she has to be informed why they have been arrested or they are in custody. Second, before a judicial magistrate, a person has to be presented within 24 hours of his or her arrest. This is a very important provision, right? And then there can be an advisory board, or there can be certain other provisions through which you can either increase the period under which a person has to be kept in the preventive detention, or any particular incident of violence or assault which needs to be adjudged by this particular committee, right? Here, remember that it's not only UAPA. UAPA is oftenly used. There is another which is NDPS. And NDPS is like evergreen, where preventive detention has been used again and again, right? Now, remember this Article 2020 Clause 7, which is that if Parliament by law provides that the maximum period of the detention can be more than 3 months, right? Then there is no need of advisory board. So if a statement comes in prelims which is related to preventive detention, which says that a person detained for more than 3 months can be only done after having the opinion of, after having such opinion of an advisory board, it is false. If parliament by law has made a law where there is a detention period of more than 3 months, a person would be detained for that particular aforementioned period without any opinion of the advisory board. Second, there can be circumstances or cases, right, by which a particular person can be detained for more than 3 months. This was all related to your article 2022 and preventive detention that you need to remember when it comes to prelims. Okay. Next, we have personality rights. So recently, I think Amitabh Bachchan had filed a case in Delhi High Court which said that his voice and personality was being misused in particular ads, and which has led to sort of criticism of his personality. So Delhi High Court provided the permission or the protection to the personality of this person and said that you cannot use his name, voice, signature, or any other feature which makes it relatable to Amitabh Bachchan. This was your personality rights case. Internationally or nationally, we do not have any definition on what is personality rights. Right now, we can only ascertain that any characteristic of a person, such as his name or voice or a signature or any other feature which makes us think of the person immediately, is his personality, and any rights of privacy which is relating to the personality are your personality rights, right? So any rights relating to the personality for the privacy issue are your personality rights. For example, if I say that, can you imagine a bald man with a stick? Most of the person or most of the people in the chat would be imagining Mahatma Gandhi. If you have to imagine a person with specs and dhoti, most of you will again imagine Mahatma Gandhi. So these are certain features of his personality which may be abruptly used in certain ads, right, posthumously, to make a ridiculous sort of opinion on him, and it may hurt the image. Courts may give personality rights to the person or his family, and it would be helping in two perspectives. First, right to publicity. You cannot use anyone's image or likeness for your commercial exploitation. For example, using sorry I was saying you cannot use anyone's image or likeness for commercial exploitation. For example, imagine an ad where you are using Gandhiji and saying that because he is wearing so less clothes, he is prone to mosquito bites. You're basically making ridiculous satire on person due to how he used to dress and how we have portrayed him in our books, right? So publicity, this negative publicity cannot be commercialized or employed by any company. Second, we have right to privacy. So for example, Amitabh Bachchan, he has a right to privacy that if I am smoking, I have never told anyone in the nation that I smoke. Or if he dated Rekha ji, he never told anyone that he has dated Rekha ji. No, no one knows. It's all gossip, right? So the person has all rights for his privacy, and personality rights also provides this particular privacy clause for him, right? Now, where did the right to privacy came from? Need to remember, need to mug up, need to have it in your brain forever. Justice K.S. Puttaswamy case 2018, which gave the trinity of articles 14, 19, and 21, under which your privacy is defined. And primarily, if I have to relate article of privacy, it would be Article 21. It is broadly governed under Article 21, but it is not solely governed. Remember, the trinity of articles is 14, 19, and 21, right? Then there's a posthumous personality rights. So we have an act where you cannot use dignitaries' names and symbols listed in the schedule. So Gandhiji's personality cannot be used posthumously without permission of government. So Lagera Munna Bhai in 2006, when it came, it was halted for one day because Raju Hirani did not have the permission to use Gandhiji in his film, right? He had to seek. So he did it somehow in one day by presenting his film before censor board, and finally he was able to release the particular picture, right? Then you have Bharatiya Danda Sahita, previously known as Indian Penal Code. Here, any defamation suit can be filed regarding any derogatory representation by any person. ठीक है? There is no I mean, how to say, fixed law that a family member can only file a case. No, any person who feels that there has been a derogatory representation of the person can file a case under your IPC, which is your BRS now. Then again, on international platform, there is no explicit international convention, right, which has been made for personality rights. Although all the rights that we have are classified under Rome Convention, TRIPS Agreement, and WIPO. Okay? WIPO was sort of a mega deal between various countries sponsored by WTO in order to finally have a clarification on your trademarks, copyrights, etc. Right? So under that, there is a subcomponent called Performance and Phonograms Treaty, where the rights of performance and phonogram producers are protected. What does it mean? That a person who is performing on stage, right? There is a live concert of, let's say, Sunidhi Chauhan or Sonu Nigam, and they have performed a particular song. You recorded it and then published it under your some music label. It is an offense. Why? Because any person who is performing or doing it offline has not given you right to do it, to publish his performance without his or her permission online, right? Okay. Now when it comes to personality rights, we have certain cases, especially the one was Sakshi Malik versus Venkateshwar Creations. So here again, some other image was used without consent, which was illegal. Again, there is no provision related to personality rights, but as we have said, any characteristic which could make you relate to a particular person is the personality, right? So here we have two provisions. Article 21, which is his life. Obviously life relates to a person, and second is his property. So a property is a characteristic of a person in some way, right? So your article 308 gives a constitutional right of property to in order to protect his personality, right. Next we have hate speech. Again, Supreme Court has stressed that there need to be a long-term solution to the problem of hate speech. Basically, if we have to brief this particular topic, it is simply there is hate speech and then there is free speech. It is all about when does the free speech becomes hate speech and whether using hate speech is a form of free speech or not, right? Both statements sound similar, but they are not. The first, while asks you for a distinction, the second asks you about the similarity. Now, if you go on Wikipedia or your United Nations official website, you will find that India is a country which has laws on hate speech. Again, there is a mechanism in our nation to fight hate speech or to conduct upon hate speech, but there is no proper definition on what hate speech is, right? For example, the France fiasco, where a person draw a particular cartoon on a religious figure, or in recent times we have seen that there were some derogatory images related to a temple ceremony, right? Any expression which is inciting a particular group of persons is generally referred to as hate speech. Again, due to lack of information, it is still incomprehensible to say that this definition works for everything, right? It is not. For example, you have flat earth believers. Now, in US, scientists are proving them that we have NASA, and guys, this is that. But a person from Texas called Jake, or a person from California, right, Amy, they believe no, because we see the earth to be flat, or we feel that earth is flat. The earth is flat. Now, any person making comment on them, or saying that they need to be psychologically evaluated, right, because of this poor belief, can they be said making a hate speech on them, right? So this is the problem where we are not able to counter what is hate speech, how is it different from free, and how much similar it is to free. Okay. Now coming to India, because as I said, India has laws on hate speech. There is a constitutional provision, Article 19 clause 2. So we know Article 19 clause 1, in that we have subsection A. What does that subsection A says? Right to freedom of speech and expression. So your Article 19 clause 2 is made to limit that particular freedom. It says that any person who is using his Article 19 clause A, clause 1 clause A power to disrupt public order, or to incite a offense, or to threaten the security of state, that particular speech can be curtailed and is generally classified as hate speech. The newly formed Bharatiya Nyaya Samhita 2023 has several sections where they have been able to make much more sense of what hate speech is. It is a broad definition, still not a narrow or pinpoint definition. First is, if there is a particular use of your freedom of speech to incite enmity between different groups, right? We have certain spokesperson making comment on religion A, religion B. Then you have punishment for deliberate and malicious acts. So for example, violating any particular structure. And then there is penalizing the publication or circulation of any assessment, rumor, or report which is causing public mischief and enmity between classes. Remember, here we had your religion and race. Then again we have religion, and finally there was a class thing. So basically, if there is a person of um, who has hatred towards Ambani or some other industrialist, just because there is a class difference, right? That person can also be tried under Bharatiya Nyaya Sanhita for hate speech. Okay. Then you have Representation of People Act 1951. This was a very important step because it was to stop our political representatives from making any injudicious or loose use of their freedom of speech. So Section 8 disqualifies a person if it is proven that he has used his freedom of speech and expression in an illegitimate manner. Then you have Section 123, Section 125. Again, if a person is found to indulge in a corrupt practice which creates an enmity between um, certain groups on basis of religion, race, caste, community, or language. Then you have Civil Rights Act 1955. Earlier, it was called Untouchability Act. We all remember there is an article. There's an article on untouchability. Can anyone recall? What is the article for untouchability? Correct. Article 70. So Article 17 prohibits your untouchability. In lieu of it, in 1955, there was a Untouchability Act that was made, and in 1990s, it was renamed to your Civil Rights Act 1955. Okay? And under that, Section 7 says that any incitement or encouragement to a particular activity which basically encourages untouchability is a hate speech. Before proceeding, Ati Murugan has wrote that do we have hate speech under the reasonable restriction article 19? So again clarifying, hate speech, it's not. There is no provision related to hate speech under article 19 subclause 2. There are 3 conditions which we have already discussed. What are they? Threat to your security of the state. Second, incitement to any offense. Or finally, disrupting the public order. Any speech made under on those grounds are not acceptable uses of your freedom of speech. It does not equate to hate speech. If it's not making sense, what I'm trying to say is that try to stay with me for a moment, right? What I'm trying to say is that when I say we know there are 5 elements in nature, let's focus on only 3. There are fire, water, and air. So when I'm looking at fire and I'm saying this is not water, right? What I'm saying, this is not water. It does not automatically translate that I'm saying that every object which is not water is fire. You're getting? Similarly, every speech made on these grounds, which are your reasonable restrictions, cannot be classified as hate speech. They are injudicious use of your freedom of speech for which you can be tried under any court. Remember guys, last year Article 19 was amended, and now if you are going to use your your freedom of speech and expression even in private conversations, right, which is going to incite any offense, or you are inciting any offense, right, by abusing a person in front of you is triable, is can be tried in the court, right? But can it be called hate speech or not is a very different question. For now, it is no. No, it is only your injudicious use. It's hate speech or not is or will be decided in courts. Okay? And then we have the Religious Institution Act 1988, again, in order to stop any institution, special institution, or their managers from promoting disharmony, right? So any particular religious place uh, uh, playing a certain message or song which is inciting hate in its worshippers is tribal under Religious Institute Act 1988. In the judicial pronouncement thing, there are two cases which were kind of trademark for Indian judiciary. They was the stepping stones in order for us to better understand what hate speech is. First is Shreya Singhal versus Union of India 2015, right? She made a comment on a particular personality. It was very out of line. When tried in Supreme Court, it said that this particular comment, the girl says she made on a satirical basis, but it had no element which was inciting either violence or public disorder. So Supreme Court said that if the investigation team finds it is inciting violence or it is leading to public disorder, the the Article 19 clause 1 clause A seems to be misused and Article 19 clause 2 seems to be breached. This was Shreya Singhal versus Union of India 2015. Next we have Amish Devgan versus Union of India, where the particular news reporter was tried or had multiple FIRs. He was not even tried. He had multiple FIRs on him, and he went to court in order to get not an anticipatory bail, but rather to quash all FIRs by saying that what I did was my use of Article 19, Clause 1, Clause A. That is my freedom of speech and expression. So I used my free speech and expression. Why is people having problem and filed cases on me? On which Supreme Court said basically that what you did was not expected from a public personality, as well as what you did is wrong, and hence the criminal investigation on you, which would be succeeding after the registry of these FIRs, the Supreme Court is not going to stop any of it. So if you are a public personality, or leave the public personality part, if you are a person and you are making a statement or making such statements which is uh, uh, not respectful for any religion and can actually be the starting point to spread of hatred and communal disharmony, the Supreme Court has said that those would be tried under the particular your criminal laws or civil laws. The court does not deem it as your use of freedom of speech and expression. Right? Next is Places of Worship Act 1991. A small overview on why it is, sorry, on what it is. Simply, it said that the institution of worship or the places of worship which had their condition, whatever their condition was on August 15, 1947, right? The religious character of it would remain the same. It provided exemptions. First of all was Ayodhya because the case had been filed in the court. Then there are certain monument and sites which are covered under Asian Monument and Archaeological Sites Act 1958. Why such provision? So for example, there is a government ABC, right? on state level, and it finds that a particular religious spot can now be converted into tourism spot, because there is a very less attraction of religious followers, or that particular religion is not being followed anymore in the particular area. The state can submit a particular request to your Archaeological Survey of India, ASI, and then the procedure could happen. So for such incidences, court says that because they are already covered under an act of 1958, they are exempted from 1991 act. And other particular places which may be tried in the court are also exempted from the same. There is a penalty if you are going to contravene this act, and it is mentioned under section 6, giving a punishment of maximum of 3 years imprisonment with fine. Okay. Now we have other important news. I need to check whether we have time or not. Ma'am, is it okay that we extend the session for another 10 minutes?
All right.
Okay, guys. So here are snippets. I prefer that whenever you are reading these on your own, try to make it like a quiz, right? Try to recall as much as you can accurately, and do not push much of your time for this. These are just your one liners. You need to take it as one liner, right? For example, we have Kui language. Now